Welcome to this evening. We're going to have a panel or three presentations on detention of children. And this morning I was talking to a journalist, and she was asking me, is it a coincidence that you're doing this symposium, this event, at the same time that things are so terrible on our south border, that kids are being harmed and separated from parents in the south? And I would have liked to say, yes, it's a coincidence, but I don't think so. I think there is, sadly, something predictable in what's happening. But do we really want to know it? That's another question. Mary this morning was saying, I do not want to hear the children cry. Well, neither do I. It makes me sad, but also afraid, quite afraid. So I think today we're talking about something which is provoking fear. And Derrida, Jacques Derrida, just after 9/11, proposed that terror happens before the event. And I think the type of terror he was talking about, was alluding to, is the type of terror we are feeling now when we prefer not to see that what is happening now is predictable. Of course, it speaks about globalization, geopolitical shift, racialization of immigration, and a progressive breach in human rights. And I think that this kind of forces us to look back and to have a historical perspective on what's happening today. It's not just about today. I think that within our illusions and our not wanting to look back, we prefer to see the Geneva Convention as universal, as a set of values we all agree on, as something which is well established, rather than the product and the reflect of a particular context in a particular time. And I think it's important to look back. The progressive breach in human rights presently, the attack on children, the attack on family, could and have largely been presented in the last decade as collateral damage. We need to enforce migratory policy. What is changing now and what is frightening, that is not collateral damage, nor did I think it was. This is psychological warfare. This is inflicting cruel and inhuman treatment, I would say torture, in order to make people frightened, in order to repel, in order to fight, I would say. Now, when we go back to history, because some people said, but it's better not to keep the kids in detention, remember, one of our first research on the topic was the London bombing. Remember, the kids who were evacuated from London to be safe outside of the bomb did worse than those who stayed under the bombs with their parents. We also have longitudinal studies of kids detained in Greece with their parents, with their mother, who were incredibly resilient. So what's going on now is serious. And it has consequences. It has consequences for children, of course, short-term consequences in terms of trauma and attachment, depending on their age. Long-term consequences also in terms of disbelief, anger, humiliation. Very difficult to see your parents humiliated or impotent. It has consequences for families, for communities of mourning their dreams, the dreams of migration, the dreams of society which can be secure or fair. And I think these are enormous grief to do. But it has also consequences for us. And it's Albert Meby, one of the first scholars of racism, who speaks of the dehumanization of colonization. And in racism, what he proposes is that the person who is object of discrimination is dehumanized, but also the person who is racist, also the colonizer. And by treating kids and by accepting as an international community that kids and families are treated the way they are, we are losing a part of our humanity. And this is quite serious, I would say, because we legitimize the unacceptable. So there is a need, and we have been talking about that today, there is a need for collective action, interdisciplinary, interfield, to buffer, I would say, not rather than to revert. We need to have realistic goals. We need to look back and learn from the historical past, but without believing that this is a repetition. It is a repetition, but it's not the same. The world is not the same. And our concern for children that we will share tonight are important not only because of the children themselves, because we want things to be better for them, but also because I think children represent a humanity bridge between us and between people. And it was, I would say, one of the last consensus that we shouldn't harm children. So that's what we're going to talk about tonight. And I will invite 3 persons, and then we'll have a discussion. So the first person is Sarah Mears, and she's a psychologist working in Australia, and she's going to talk to us about the detention of children in Australia and the harm to their mental health. Sarah.
Thanks very much, everyone, and thank you, Cécile. Thank you for inviting me to come all the way from Australia to speak. It's very unfortunate and to our shame that we're somewhat world leaders in immigration detention, having been detaining children and families since 1992, although it only really became a sort of more public issue around about the year 2000 when numbers in detention increased. So I'm a child and family psychiatrist from Sydney, and a lot of my clinical and academic work has actually been about early intervention and prevention, the importance of the early years, working with families and infants at risk of transgenerational and kind of lifespan effects of adversity. And children in immigration detention are obviously one such very vulnerable group. So this is just to remind you there are different ways of seeing the world. My talk includes drawings done by adults and children while they were detained, and although some of them are available on the web, they were actually provided to the Human Rights Commission during the more recent inquiry, and we have permission for the purposes of the inquiry, but not to for them to be reproduced or disseminated. So I'd just appreciate if you didn't photograph the drawings that I show. So just a few obvious points. Children are dependent on adults for care and protection, and so we do have to think about the adults who are parents as well. Over 50% of displaced people, of the 67 million or whatever it is at the moment, that the UN estimates, are under 18, and about 20% of those who come by boat to Australia are under 18. There's a lot of evidence, as we know, that PTSD and depression impact on parenting, and I've just listed a recent Australian study of a fairly large cohort of refugees, and these are refugees settled in the community rather than necessarily those who'd been detained, and that showed that harsher parenting was more likely if parents had PTSD. We know long-term that cumulative adversity has worse developmental impacts, and that detention is both a high threat and a high deprivation environment, which profoundly undermines the capacity of parents to care and protect their children, no matter how good they are. So this highly politicised area of research and practice that someone said today requires some stamina and a lot of support to work in. Now, just before I go any further, in Australia our way to begin such meetings is to acknowledge the traditional owners or the first people of the land that we're meeting on. And as well as that acknowledgement of the continuing relationship with the country, it's also a reminder that for most of us in Australia and probably Canada too, we are migrants. I actually was a baby and came on a boat with my parents. I don't know how much that's true for you. So in Australia, I live in Sydney on land of the Gadigal people of the Eora Nation, and I'm afraid I don't know which country we're on at the moment, but I would like to, Mohawk people, pay my respects. So there's a 60,000-year history of Aboriginal and Torres Strait Islander culture, and Aboriginal and Torres Strait Islander people make up about 3.5% of the population of Australia. In a way, Cécile led into this very well, because I think in Australia we go, how did we get to this point? And I suppose we try and make sense of it a little bit by looking at the more recent history, which is less than 250 years since the British invasion and colonisation. From 1901 to the early 70s, we had migration was influenced by was called the White Australia policy, which I think speaks for itself, but it privileged European immigration, or more strongly probably than that. We had a fairly generous refugee intake from Europe after World War II, and have continued to be considered generous per capita in terms of the UNHCR resettlement program. And then in 1976, when the White Australia policy was overturned, in the following years, about 100,000 refugees were resettled from Vietnam and Indochina. And during that time, the term boat people entered the Australian lexicon, because about 2,000 or 3,000 of those people came by boat. And at that time, all of those people, refugees and boat people, were all welcomed. They were offered English language, settlement, education, and subsequent studies of the Vietnamese in Australia show that they actually have better mental health outcomes than the general population. So there is a lot of evidence of both kinds from Australia, both of what is really helpful for displaced people resettling and also of what does great harm. So we live, this is a population distribution map, we tend to live around the edges, particularly the southeast coast of Australia. And then this map shows immigration detention centres. The black ones are the city-based centres. Generally, people who have arrived with visas and overstayed are kept there before deportation. The centres with red dots around them, as was shown earlier today, are Nauru, the tiny, very poor Pacific island of Nauru, and Manus Island, which is a province of Papua New Guinea, where Australia currently, since around about 2013, has had a policy of sending anyone who arrives by boat to seek asylum. The places with the yellow dots are where most of my published work has come from, and they're both extremely remote places, as you can see. I mean, Australia's not quite as big as Canada, but it takes 4 hours from Perth to fly to Christmas Island, for example, and it's very often those flights are very disrupted by the weather. So we've had mandatory indefinite detention of all children and adults who come by boat and seek asylum since 1992. The policy has fluctuated over that time depending on political circumstances, but generally it has been hardened, particularly in the last few years, with changes to the migration zones, making it harder for people. So even if they have reached outskirts of Australia, now they can no longer claim asylum from those points. It's very important to say that over 90% of the people who come by boat to Australia are found to be refugees once their claims are processed, whereas the number of people who come by air to Australia with visas and then seek asylum, or people who overstay and then seek protection, have very, very much lower rates. So the people who make those dangerous journeys generally are confirmed in their refugee status. So currently, in 2013, there was this change which really was a very harsh removal of hope for anyone who came subsequently by boat, or who was kind of in that in-between period. They arrived by boat not knowing Australia had started sending all these videos, which of course they weren't able to watch, saying if you come, you will never be resettled in Australia, your claim will not be processed in Australia, you'll be sent to Manus or Nauru. And the other thing that happened around that time was that there was a sort of a halt on processing any claims. So there came to be 20 to 30,000 people whose claims weren't processed for years and years, and many of them are still not processed. But again, because once those claims are processed, they're found to be refugees, then they can't settle in Australia, so where are they going to go? So even though people now are on Nauru, not in detention, effectively they are still detained because they're on Nauru and they can't go anywhere else. There have also been quite a lot of violence in both those places, and recently another death by suicide, but also riots and a lot of sexual violence against women on Nauru. Oh, the other thing there, obviously, is that now all of this is justified as humane deterrence. Mr. Trump doesn't seem to be using the word humane, but as we know, language is very slippery. So, as I said, we have two sides to the story here. We resettle 20 to 30,000 people a year under UNHCR, and then we have this other very harsh process, which has been explicitly deterrent for going on maybe 10 years, but less explicitly deterrent before the time before that. So there's been considerable condemnation of our policies, which doesn't seem to have made any difference. So there are many challenges to research with detained populations. And again, this was discussed a little bit earlier today, but one obviously is access practically. They're very remote centres, but also politically and kind of institutionally, it's very hard to get access. And then there are issues about consent and confidentiality and who owns the data and sampling and all of these things. But so the research that I'm going to talk briefly about that we have, I and other colleagues have been able to publish, has been opportunistic. There are many limitations to the data, but there's also many reasons why those limitations are in place. So this is a drawing by a 11 or 12-year-old Syrian child, which shows very clearly it's a very articulate drawing. It gives a lot of information. If you read it from right to left, this is the stages of the refugee journey, effectively. Home with the bombing, the dangerous boat journey, and then detention. It's also a really interesting drawing because it helps us think about children and children's experience at different stages of that journey and how that differs depending on their developmental stage and capacity. So, for example, the child who's drawn this drawing obviously remembers these things, was exposed to the bombing, has been on the boat, and now is in detention. But the infant, the baby-to-be, the person-to-be who we see in the mother's tummy, because you see the family composition has changed, that infant hasn't had these experiences, but in utero is exposed to all the adversities associated with the family being detained and having had their hope of settling in Australia removed. And as well as that, in detention, we know there's very often very little choice of diet, very limited healthcare, although the government would deny that. It's not of the same quality as is available to people in Australia. So there's a lot of information in this drawing that I think helps us think about children and about children's experience. The other thing is that most children would write their number before their name, and some would only write their number. And this is because although between 2002, when I first went into Woomera Immigration Detention Centre, there was no pretense. People were only called by number. In 2014, now there's this sense that, you know, apart from the excuses, oh, everyone's called Muhammad, how come we have to use the number? These days there was, you know, a denial of calling people by number, and yet still the children would always put their number before their name on the drawings. This is a drawing by, obviously by a woman who's pregnant and thinking about her baby. And, you know, in many ways we know that women and parents generally who think about their children in utero before they're born, this is a protective factor. It indicates an engagement and investment in the child, promotes likelihood of good bonding and attachment antenatally. And yet this parent and the child before they both show in their drawings some considerable competencies and strengths, and yet they're in this entirely adverse context. So the sources of evidence that we have about children, the impact of immigration detention, are the children and adults themselves, as we've already seen. There have been 2 Human Rights Commission inquiries, 10 years apart. There's some research. And in Australia, the first papers on the mental health of detained adults came out very soon after the policy was introduced. Then there was a really important paper called a participant observer account by an Iraqi doctor who was detained. And he actually, that was Dr. Sultan, and he included some observation about children, which were very prescient and really haven't changed. And then I and some other colleagues have tried to publish some other work about children, and our paediatric colleagues as well have been very active in this. But there's also some government data. I think they really regretted collecting it, and they stopped once they realised what it was going to show. But there is government Kessler 10 scales for adults and strengths and difficulties questionnaire data, which has been obtained under Freedom of Information. Plus other accounts. In Australia, there's also an increasing number of compensation claims by refugees, people who were detained, but also by workers in the centres. But generally, they're all settled out of court so that the evidence doesn't become public. So this is what Woomera looked like when we went in 2002. And this is a drawing from that time when there'd been a lot of riots and they were put down very violently. But you can see in this drawing, there's a baby in the parent's arms here, there's another child over there. And you can see that children are unable to be protected in detention. But they're also very clear in communicating their experience. So we wrote this paper. I think we were so shocked by what we'd seen, and we concluded it. We wrote, immigration detention profoundly undermines the parent's role, rendering the parent impotent, unable to provide adequately for their children's physical and emotional needs. Parental depression and despair leaves children without protection in an already terrifying and unpredictable place. Parents are unable to provide for them adequately or to shield them from further humiliation and acts of violence in a degrading, hostile, hopeless environment. And concluded then, having been witness to the distress of families and children, having asked for their stories and heard them, we feel an obligation to report what we have seen and understood. And I guess I hadn't read that paper for a while, and when I did, I realised how powerful that first experience had been, and how the clinical issues, we were asked to go in and write reports for lawyers representing families who were trying to get them out of detention. But actually, you just cannot separate the context from what you're seeing. And as I say, it just felt impossible not to have a sense of responsibility. So the first Human Rights Commission an Equal Opportunity report came out in 2004, and this was their conclusion. The failure to, it was a very big report. Okay. So there's a lot of other issues there, but this is what it looked like on Christmas Island in 2014 when I had a week there. So this is called an alternative place of detention. It still has a large fence and it's still essentially a detention centre, but it's not called that. These are some drawings from children at that time, which show much more about the deprivation of the environment, the kind of desolateness, the lack of anything to do, rather than the violence they were exposed to, although there were protests at that time. And here's another picture of people lining up. Parents who were feeding babies could only get 3 scoops of breast formula at a time, or only 3 nappies. They had to line up again, they had to line up for everything. This is a note from an unaccompanied child, just to remind us of their particular vulnerability. So this report found very similar conclusions to the report a decade earlier, but this is just to show that, interestingly enough, the numbers in detention before each inquiry were around about 2,000 children, and with increasingly long periods detained. So in 2014, most of the kids had been there 8 or 9 months. those who are still on Nauru have now been there several years. But essentially what happened before the release of each of the human rights inquiry reports was that somehow miraculously the government found a way to get all the kids out of detention. So that's where you see these steep falls in the numbers. So although what happened with the release of this second report in 2014 was that the difference was in 2004 the evidence was contested, it was disputed, and soon after that, just quietly, some protective amendments were put in place to consider detention as a last resort. But in 2014, the whole report, the Commission President, the Commission, the whole body, was met with extreme hostility. There was no argument about the findings. There was attacks on the integrity of the Commission and the reports, and the harms were, again, justified. But there was also criticism in terms of over-reliance on medical experts and the use of the term advocates as an insult, so to undermine the notion of expertise. So again, there'd been a change as well in other ways in the language used, so that guards were now, we had to call them officers. Children were having best interest assessments before they were sent off to Nauru, although nobody ever failed any of those assessments. Parents were given full autonomy and so on. So the psychological support program was actually solitary confinement with 24-hour. You know, it was very insidious, actually. It is very insidious. Just a reminder of the poor physical health of some of these children. And that, as I said before, I think a way of understanding the complexity of the detention environment and why it is very bad for children, even with their parents there, is that it involves both considerable deprivation but also unpredictable threat. And there is this significant impact on parenting and parental mental health. So this is just the government data that they were sorry they collected. This is not offshore, this is onshore. They had results similar to a community mental health population. And the children, particularly when they did the Strengths and Difficulties questionnaire, 82% of children were scored in the abnormal range. So there was data collected by the Australian Human Rights Commission as part of that inquiry, and I had been involved in designing the methodology, which in the end the Commission didn't use because they were concerned about having used the Strengths and Difficulties questionnaire and the K10. They didn't want to be accused of doing a clinical assessment. So I knew that data was there, and I obtained it under freedom of information and then did a secondary analysis of some of that data, and it's remarkably similar to the government's own data. But I included the concerns that parents had about their infants, because children under 4 generally get left out of most studies, and yet we know that's the most important and formative time. So, and you can see the results there. Hopefully I'll have a bit more chance to talk about this tomorrow. And then we compared it with a sample of Strengths and Difficulties results with a sample of children who were refugee children who'd never been detained. So they were settled under the other government program, and you can see there's no overlap at all in the scores. So protective factors we know are rapid resolution, stable settlement, social family cohesion, and so on. All of the things that Australia is doing at the moment is the opposite. I just have this slightly provocative question. So has our advocacy been ineffective, or in a way has it been too effective, in the sense that now the current narrative of deterrence actually uses the evidence that we have gathered to turn it around and somehow then distort and justify the process? So it's a very tricky business we're involved in, because it's not enough to keep saying this does people harm. They're going, yeah, we know, that's why we're doing it. And that is a change, that's an insidious and horrible change. But the other thing that is, I feel conscious of, is that when we have, for the purposes of advocacy, we have narratives of everyone's damaged, of permanent harm, we're actually leaving out the fact that some children show incredible resilience, that children have really different capacities. And for example, the children's drawings I've been showing you, this child has expressed very clearly the injustice. And I think, you would say this is, again, another very articulate drawing. So the summary, I think we see rates of distress that gets worse with time detained. It's a public health issue as well because of the amount of money spent. And in terms of advocacy, detention of children has been less politically palpable in Australia than detention of adults. It will be interesting to see what happens with the States. And we need support to do the work because it's extremely hard to keep going with it. Thank you.
But we do now have Michael, I will mispronounce your name, Bochenek, who is a senior lawyer, human rights watch, who will talk about immigration detention of children and family in the U.S. You should forgive me the pronunciation of your name and correct it, please.
Great. Well, thank you very much. And when I agreed to do this talk about a year ago, I guess, I had in mind a very different kind of talk than I find that I'm giving today and have indeed been talking about all week and last week. So right before I came here, I was down on the U.S. southern border in McAllen, Texas, and I was looking precisely at the issue of what is happening right now in U.S. immigration detention, what is happening with families who arrive, and what is the current situation, what is the outlook. This is very much a moving target. Obviously, this new policy, extremely heartless new policy, has effects that are just beginning to be appreciated. So I think a lot of what I'm about to say is going to be either descriptive or will be, in some sense, projecting the kinds of things that we can do as ways forward, but it won't be anything like the kind of organized, bullet-pointed presentation that I may have had in mind a little while ago and that I had started to write when I agreed to do this. I'm going to start just by talking about some of the things we may be hearing about, some of the terms we've been using, including the places that people are held, families with children, adults and unaccompanied children. And so because what we're talking about here is a whole process that involves different kinds of detention for different periods of time with different conditions. And so the first thing that is most common, the most common place that people go upon apprehension at first is a facility like this one. Its technical name is a Customs and Border Protection Holding Cell. These are known colloquially as the freezers because they are very, very cold. And that is no joke. They are really cold. I was in one of these on Thursday, and at various points during the day, with wool outdoor gear, I had to get up and walk around a couple of times because I was shivering uncontrollably. Now imagine if you're sitting on one of these concrete benches or sitting on the floor wearing wet clothing that you haven't been able to change, you haven't had a shower in several days, you've crossed the river, and it's now 13 degrees Celsius in one of these cells. That may feel fine to a border guard who's wearing a full uniform, but eventually and quite quickly, people will feel very cold. That's particularly true because for a very long time, it may not quite be the case anymore thanks to a lot of advocacy, but for a very long time, people were instructed to take off all layers of clothing except for a single t-shirt. That was certainly the case up until about 6 months ago. One thing that I noticed when I was in there on Thursday is that people were now allowed to wear a t-shirt and a sweater, which is an improvement, but it is still quite cold. I was wearing more than that and I was freezing. So this is the freezer. This is a holding cell where people are taken to immediately upon crossing an apprehension. And they're normally held there for a relatively short period. At the moment in particular in McAllen, people are going from after about 12 hours or 24 hours to the next stage in the process. And these are clearly intended to be very short-term facilities. When they were designed, really the idea was a couple of hours and move on to the next place. In fact, we know that in recent months, in the past year or so, these facilities, particularly when you get to more remote parts of the border, that these facilities can be used for days. And so although Customs and Border Protection strives to move everybody out kids out within 72 hours, and in fact adults as well, we know from their own records that they don't often adhere to that. So that people, children as well as adults, have been held there in recent months for a week or even longer. So that's the freezer. Then we move on to the processing center in McAllen. We've seen a lot of pictures of this because members of the U.S. Congress toured it over the weekend, and Customs and Border Protection released images. These are government photos. They didn't let us take any photos. They never do. And I think they finally had to release some images to show what was going on. This is not inaccurate, but it is fairly well staged. That is, everything that I saw was far, far more crowded. So sitting in this facility, you see a lot of different cages. This chain link fencing is separating, which you can see at the back of the first photo, is separating areas where people are sitting. And what we're looking at is actually I think the desk that I was sitting at is right over to the left during most of the time that I was in this facility on Friday. There's a lot of different caged areas where they're housing, in this section, kids unaccompanied, or in some cases with mothers. And then adults are housed in a separate wing of this facility, which it looks even worse, to be honest. So bear in mind that this is a government staged photo. It is quite clean, it is quite empty. What I was seeing was far, far different, was large numbers with people sitting, kids as well as adults, sitting on these green mats, wrapped up in these foil blankets with very, very little to do. Let me say that there are a couple of things that are better at the margins about the processing center, which is known as Ursula because it's on Ursula Street in McAllen. There are a couple of processing centers. There's one in Arizona as well, but there really aren't as many as there are of the first immigration holding cells. In contrast to the holding cells, or in contrast to the freezers, people get showers when eventually they may get, at least kids do, maybe one. Maybe it's right away, but maybe it's after a couple of days. So eventually here, unlike the freezer, kids will get a shower in many cases. The temperature is not as cold. The food is slightly better. Unlike in the freezers, they have access to toothpaste and toothbrushes. I actually can't imagine not brushing my teeth for days. That to me is almost as shocking as everything else. One thing that's hard to tell from the picture of the freezers is that in the back, you can almost see that there is a half wall where there is a toilet. And in many of the cells that I was seeing on Thursday, there were 15, 20, 30 people, 30 teenagers, 15 adults with their kids. These rooms can get quite full. And so a lot of the things that women told me when they were in these cells, reflecting back about their time, is how humiliating it is to have to use the toilet when everybody's right there on the other side, when you can see them if you stand up, where you may be so crowded that people are actually leaning up against that wall. And so boys were talking about moving a trash receptacle to give them some privacy, asking people to move to the other side of the room. I was doing interviews in at a station, not desk is too grand of a term, at a station that was right facing the cell that was being used for adult men who were there with their kids. And so all adult men with children were held in one of these rooms, which meant that they had boys under 11, but also girls under 11. And so I asked a 9-year-old girl what it was, whether it caused her any consternation to use the toilet with a room full of men. And she didn't really want to answer that question for obvious reasons. I think it was not comfortable. In contrast, at least in the processing center, the toilets are separate. You have to ask to go use them, but they're farther away and offer a greater measure of privacy. Privacy there isn't much of in any event in these facilities. Lights are on 24 hours a day. It is not set up in any way to provide anything like basic levels of comfort for any person, much less a child. Now let's quickly, because we're going to hit the time limit in a second, address the issue of separation. Separation happens in general at the point sometime after families arrive at that first detention facility before they go to the second one. And I think here I have to explain a little bit about the rationale in US government terms for this separation. It is not required by law. Up until 2 months ago, even the Trump administration was not doing this. There is nothing in US law that requires it. There is nothing in any court settlement that requires families to be forcibly separated. This is a policy choice, and this is a policy choice that deploys a couple of tactics very, very cleverly, nefariously. One is the idea that the parents have committed a crime. They are being charged with a criminal offense, and therefore they are subject to time in federal prison. Hypothetically, this is true. It is both an immigration offense, an administrative offense to enter without inspection, as well as a charge on the criminal statutes. It's rarely been used in that way up until now for first-time entries, in particular because a lot of the people we're talking about have fled persecution, have fled risk of harm, may have crossed without inspection, but it is not illegal to seek asylum after crossing the United States into the United States without inspection. And in fact, most of the people I spoke with presented themselves to immigration officials at the first opportunity in order to try to seek asylum. So it is a little bit incredible that you would then say, aha, but you are also a criminal. As a matter of sound public policy, this seems crazy. Why don't they just go to the bridge? And there are bridges across the river, there are regular border posts. Why don't they go there and apply there? 6 months ago, it was possible to do. You could walk up if you said, I'm an asylum seeker in principle under the applicable regulations. The immigration authorities were supposed to let the person in to pursue an asylum claim. They could be detained if they were adults, but this was a possibility. Now, if you walk to the bridge in McAllen, the bridge between the US and Mexico, there are Border Patrol officials standing at the midpoint, blocking entry to US territory. Because if those folks get to the passport control desk, by regulation, they should be let in. We had problems even before the past couple of months with border officials randomly turning people away. But this is a new order of obstruction, right? So now people are being routed. They either have to hang out on the bridge or hang out somewhere on the Mexican side of the border and wait to be called up. It's not really clear when they're going to get up to apply for asylum. Or they cross the river and try to present themselves to immigration officials. So the idea that you would then criminalize people for doing this seems utterly farcical, and yet this is what's happening. Second, they're not actually spending time in federal prison. This is not a serious crime. This is a misdemeanor. A misdemeanor that's a term that covers a broad range of crimes for which imprisonment is more or less under a year. So for the most serious misdemeanors, you might be locked up for up to a year. For a misdemeanor like this, the federal judges are giving time served. Time served not in a federal prison, but time served in immigration detention, time that they would have served anyway, time that they would be locked up for ordinary processing, which makes this akin to an offense like jaywalking. Jaywalking is a misdemeanor in some US states. It's rarely charged and then only discriminatorily, right? But nobody gets prison, rarely. Well, there are some famous cases, but you would rarely think that you would get prison for crossing the street against the light. You just don't think that would happen. I do it every day. I live in New York City now. Of course I do it every day. It's required. More than that, though, you don't think that having your kids taken away from you is a logical consequence for a crime like jaywalking, even if it is technically a crime. So we're not seeing lengthy prison sentences in any case, even with repeat offenders. Most people are getting out of the court system in 2 or 3 hours, and they're back in one of these facilities or in another immigration facility. Nothing in this suggests that it would be impossible to reunite families. And yet, the current administration is using the excuse of the charge as the way to justify separation, forcible separation. All right, so I guess there are admittedly a couple of other things. Can you hear me? No, there are admittedly a couple of other things that are also going on in the minds of the president, in the minds of the attorney general, and whatever she may say, the Secretary of Homeland Security. And one of those is deterrence. Okay, we've seen a lot of shifting. If you've paid any attention to the news, you've seen a lot of shifting justifications for what's going on. It's the Democrats. It's the law. We know it isn't. It's the Bible that maybe requires it. I never knew that in a country that has formal separation of church and state that we would be invoking the Bible, however inaccurately, for any public policy, but there it is. What really comes down to, when you get down to these statements, is number one, deterrence. We just heard about this in the Australian context, the idea that you will prevent further arrivals by treating people incredibly badly, by tearing apart families. Other people won't come. And then the second justification that I think hasn't been admitted, but I think is in their minds, is punishment, right? Extrajudicial punishment for people who, the president has referred to in terms like infection or infestation, using the most vile terms imaginable to refer to human beings. So what are the solutions? I mean, this is where we're speculating, or just sort of like thinking about the possibilities. There are what I think, because the president in particular, with his art of the deal, is always looking for negotiating tools. He's very clearly has all but admitted that this is a negotiating tactic. He is using children as pawns in a high stakes poker game that allows him to get an immigration law he wants. There is a bill currently in the United States Senate that would say, well, we really hate to see this family separation. Let's lock them all up instead. Which cannot be the answer, right? Unfortunately, I think there's now a lot of political inclination toward that on the part of, at least of the majority party, because they want to be seen to be doing something, and the universal condemnation worldwide, and not just from the usual suspects, but from the likes of evangelical preachers, the former First Lady, Republican First Lady, Republican Congress people, and so on, is such that they can't let this go on. So I think it would be disastrous. It would be beyond nefarious if what we ended up with as an outcome was an increased use of family detention. We know from the previous speaker, we know from the discussions we've had this morning, we know from the next speakers and throughout the course of this conference, just how traumatic detention is, of any duration, but particularly in the context of flight from serious risk of harm and a whole set of attendant policy choices that inflict further harm. We know that this would be a really, really bad outcome. And I think it's incumbent now to try to seize this moment, really to galvanize opposition, not just to splitting apart families, but also to any effort to increase the use, to return to the widespread use of family detention, which was a practice that Human Rights Watch rightly heavily criticized during the Obama administration and previously. The status quo that prevailed for the last couple of years is far more tenable in human rights terms. Because of the way that federal law works and certain court settlements, children should only be in these by law. Let's not talk about standards, which are far more stringent, but by U.S. law, children should only be in these immigration facilities for a relatively short period of time, 72 hours, or maybe in exceptional cases interpreted to mean large numbers, 20 days. Already far too long. But the good aspect of what existed up until about 2 months ago is that at the very least then they would be transferred to slightly better facilities And in many cases, particularly those with family members, either unaccompanied kids with family in the United States or another sponsor, or in the case of family units who could show that they had some ties to the U.S., release to serve, to wait for an asylum hearing in the community, which is far better. There were still abusive practices, the overuse of the, what do you call it in English, the electronic tagging or bracelets, these horrible things that you have to keep charged all the time, that cause a lot of chafing and burning, are profoundly humiliating. Often they're quite big, and so you know that somebody is on one of those things, used only for adults, not for children. But at the very least, ideally not this alternative to detention, but other forms of reporting and check-ins and so on were being used in a way that did not entail these kinds of harms. That's what I would like to see. I guess I'll end with an open question. I don't know what we'll end up with, either the extreme of the current approach where families are torn apart, the only slightly less bad alternative of renewed, increased family detention, the status quo as it existed before this all started, or something in between. I can't think of what that would be. So unfortunately, I'll stop there with no real answers. Thank you.
Rachel Kronick, a dear colleague. She's a child psychiatrist and, as you see, a mother of 4. So she have certainly different stance to speak about kids. And she will talk about child detention in Canada, recent development. I think this has been a topic dear to your heart.
Thank you. So my focus today will actually be on giving you an update on detention of children in Canada. That said, I know that this is an international audience to a large degree, and there's some of you who don't have the information before the update, so I'll try and sprinkle in some information to give you a sense of the past, though it's quite recent. So first, an outline I want to share with you a bit how I entered this field and why I'm doing this work as a child psychiatrist, advocacy that emerged in Canada over the past 3 years, new guidelines developed by the government and by the Canada Border Services Agency regarding the detention of children, and then talk about, hypothesize together about what these new guidelines might mean. And share with you the little bit that we know about the implementation of this new directive. So how I entered this field, my mentors, Cécile Rousseau and Janet Cleveland, were doing important research on vulnerable adult asylum seekers in immigration detention, a large quantitative study. And I was a resident at the time, and Cécile invited me to join them to look specifically at the experiences of children and families in immigration detention. So with their guidance and support, we did a smaller qualitative study on the experiences of children and families in detention. And while it was a small study, both the research projects, certainly the adult project and the child study, was significant because, as Sarah Maris has outlined, and everyone who's spoken about doing research in immigration detention, it's very hard to access. And there have not historically been researchers who've been allowed in immigration detention in Canada. So it was a small piece, but given the context, it was a big deal. So just briefly, I'm not going to have time to describe the conditions of immigration detention for children. Hannah will be speaking with others tomorrow, talking about the scorecard on children in detention, and can hopefully provide a fuller description of what immigration detention is like in Canada for children and mothers and fathers. But briefly, children are held in immigration holding centers, IHCs, that resemble medium security prisons, where their personal effects are confiscated, they're surveyed by guards, And in other cases, when children are not held in immigration holding centers, there are 3 main immigration holding centers, one near the Vancouver airport, one here in Laval, a suburb north of Montreal, and then one in Rexdale in Toronto. If children are not held there, their parents may be detained alone, and they would be separated from their parents, and they'll either go and live with one parent if only one of their parents is detained, or they would live with extended family for the time of their parents' detention, or be in the care of Child Protective Services. So again, I'm not going to get into the details of our research, but I want to present 2 very, very brief case vignettes to give you a sense of the texture of the experiences that children and families have when they live through detention. So just very briefly, and I actually picked 2 cases in which that could still happen under the new guidelines. So this was Syed. He was age 9, and his family had fled their country of origin for religious persecution after his eldest brother, who he was born after his brother disappeared. His brother disappeared and was believed to have been kidnapped and murdered. They came to Canada. Their refugee claim was rejected and viewed as not credible. And a lot of things, there were a lot of complex post-migratory stressors for this family, suffice it to say, but one of them was for 48 hours, this boy and his siblings and his parents were held in immigration detention. 48 hours is relatively brief and something actually that most of us would be advocating for. But Syed, in addition to having this experience of terror while in detention, he developed very severe, from our psychiatric perspective, very severe anxiety for a 9-year-old boy, and was so anxious after release that he wasn't able to attend school. He was scared of vans because he had been taken to the detention center in a van. He developed a phobia of people in uniforms. He had difficulty sleeping, and we really saw a boy who had symptoms that ended up persisting for months after this arguably very brief detention. So this is actually an image. I'm not sure how well it shows up on the large screen, but one of the things, I'm not going to get into the details of this, but we did sand play interviews with the younger children in detention, and this is an image taken from one of the worlds they created in the sand. So this is a story of Isaac and Jacob, who we met in our research, ages 5 and 3. Their pre-migratory story, briefly, their father was a human rights worker in their country of origin, was jailed and tortured for several months. While he was in jail, militiamen entered the family home and raped the mother in front of the 2 boys. Thankfully, the father was released from jail. They fled, but they had to flee separately. So the father fled with the 2 boys. The mother fled a few months after. She fled within the country, and then she came to Canada a few months after. The boys arrived with the father. They were not detained on arrival, and they began to integrate and to build a life. The youngest was going to the garderie, to the preschool, and the eldest was in kindergarten. And the case came to our attention when the school contacted our community mental health service because the boys were suddenly deteriorating in school. And that was because a mother had arrived and she was detained because the CBSA officer who assessed her didn't believe her identity was certain and actually even questioned if she was the mother of these boys and the partner of this father. And the boys became again, from a psychiatric perspective, they were very unwell. They went from boys who were, learning the language, making friends, to boys who were very aggressive, who wouldn't leave their teacher's side, who were no longer able to do the things in school, were having regression of their milestones. So this was a case where the children, in fact, weren't detained. They were protected from detention, but the detention of their mother had an enormous impact on these boys. So that's to give you a sense of some of the kinds of things that have happened when children are detained. following our research, now there's been advocacy around this, the issue of children in detention for many years in Canada. The CCR has done very important work. The work has been ongoing. I think there's been a particular push in the last few years, as Samar and Hannah articulated earlier today, for those of you who are there, on intersectorial advocacy. And so we saw Samar and Hannah's report release that garnered a lot of attention. And we saw a statement released against immigration detention of children that was signed not just by child advocates, but was signed by important physician groups. It was signed by important NGOs. And we saw this kind of swell of an effort around immigration detention that was really multivocal. There was also important litigation. We were hoping Andrew Brower would be here, but he, among others, Justice for Children and Youth, litigated some very important cases, trying to make sure that the best interests of the child would be considered in these contexts. And as I said, it was like we have a new government, but it was like the first time for a while that maybe something was being heard. And we had a government who said it wanted to end detention. And most recently, November 2007, there was a national directive for the detention of children that was released. This, as you can see, this was very, very recent, and it was in fact CBS. This is a directive from our Canada Border Services Agency, CBSA, and it was developed. They consulted with the many of the child advocates and NGOs who were who had been voices advocating for change, and so I'll share with you some of the pieces of. I can't share with you the whole directive, but the key objectives, so you'll have a sense of the direction. One was to stop detaining or housing minors and to stop family separation. I should point out, again, for those of you who don't know the context, that there were two phenomena happening, that children were formally being detained, but there were also many cases of children not actually being legally detained, but de facto detained or housed with their parents. So their parents were issued a detention order. The children weren't. Initially, they weren't actually being counted in the statistics as detained children. But for all extensive purposes, they were living the same experience as a child who was formally detained. So to actively and continuously seek alternatives to detention when unconditional release is inappropriate. And we can, of course, ask together what would that mean, unconditional release being inappropriate. To preserve the family unit is acknowledged in these objectives. To ensure that it's for the shortest time possible. Again, we have to ask, based on the research, knowing that even 48 hours has the potential for harm, what are those timelines? To never place a minor in segregation. Hopefully Hannah might speak to that a little bit tomorrow, given there have been cases of unaccompanied minors being held in segregation in immigration detention. So I'm highlighting some of their fundamental considerations that I thought were important, not all of them, but it's important that we note that the unity of families is really prioritized in this document, and as are the best interests of the child. They're acknowledged as a primary consideration, though it does state that it can be outweighed by other significant considerations such as public safety and danger to the public or national security. So we can discuss the implications of that. So I ask you, what are the results? I'm not going to be able to show you the results, but I thought it was interesting. Blarina mentioned earlier today that it's not only important to measure the harm done by detention, but also to measure what is the response to that harm. And I think in Australia you gave us sort of chilling example of the response to harm being bring on the harm. Let's try and understand what the response to this knowledge and advocacy has been. So let's look first at the numbers. Firstly, it should be acknowledged that one of the, I think we can say, successes of the advocacy is that the numbers are being counted. We now have a much better sense. We now have a sense of the de facto detained children in detention, and we're having much more precise breakdowns of who is detained, where, why, and these numbers are being released transparently immediately after a quarter of a year. So these are numbers we got access to through access to information. In 2000, 2008, 2009, 794 children, but I put that star because remember this was a time they were not including de facto detained children. 2010, 2011, again, the numbers have gone down, but it's not including de facto detained children. And then for the fiscal year, these are CBSA numbers, 2016 to 2017, which does include de facto detained children. We have 162. And then this is the first 3 quarters of 2017 to 2018, which is in fact just 2017, if I've understood correctly. And we're at 155 children. Action Réfugiés Montréal, that's the NGO that goes in to support detainees in Montreal, has shared with me that based on their records, and their records don't count every single detention because they're only in on Tuesdays and Thursdays, but their records have shown that there have been 26 children detained in 2018 and 1 unaccompanied minor. Okay. So children become visible with CBSA's work and with their new directives. They're visible statistically, and that's very important. It's also very important that CBSA has acknowledged that family separation is harmful, and they've acknowledged that they are doing what they can to avoid it. I want to note one of the interesting things is regional differences. And while in Toronto, 9 children have been housed or detained in the Toronto IHC in the first 3 quarters, in Quebec, the numbers are different and much higher. 23 de facto detained, 79 formally detained. And I have some of my own hypotheses of why there might be these regional differences, but I hope the Canadians in the room at some point we can talk about why these differences might be happening, and I'd be interested to hear from CBSA their own perspective on why they believe these differences are occurring. Of course, because we know the decision to detain is Hannah and Samar have documented how discretionary these decisions are, it's concerning that there are these regional differences. Oh, I'm sorry, you can't see the second line there. It's also important to contrast with the adult numbers because we have high numbers of adults detained, and in fact, it's the first time in a decade or longer we've seen a sharp increase in the numbers of adults. And we're actually, one thing we're not counting, which I would love to see counted, is we're not counting the number of parents who are detained without their children. And we can hypothesize or imagine that if the numbers of detained adults are going up, probably some of these are parents of children. So children's separations, we don't know. They may be stable, they may be going down, or they may indeed be going up. So this is what I said. This is an image from the sand play world. One of actually Syed created. And remember, he told a story of a incarcerated man, and remember, he also had a brother who had been kidnapped and disappeared. The other question we have about these new directives is there's been an emphasis on the best interests of the child, which is certainly a success. The question is, how are these principles being implemented? There was actually a working group that again involved Hannah and UNHCR and CBSA and child advocates sitting down together to develop a tool to assess the best interests of the child that officers would use, and it would be a way that these decisions could be recorded, and so we could understand how officers were making their decisions. And actually, maybe we'll get an update from CBSA here, but we actually don't know where that process is at. And as far I hear from legal colleagues that we're not having evidence of how these decisions on the best interests of the child are being made. So This has also been emphasized. This is at the level of guidelines and policy. We still need legislative change. And I would argue, given this involves this is highly relational, these practices, that we need change in the microculture of CBSA, in how officers interact with children and with families, and indeed with all detainees. And many have spoken to this in Canada, the need for independent oversight of CBSA. And of course, we talked about earlier in our discussion advocating for the most vulnerable. When we're advocating, and children fit into that category, arguably, but we've had this change in the directives with children. Surely now it's time for some changes with regards to the detention of adults. So thank you. May I extend my thank you by 1 minute? Because I know who's giving closing remarks for the conference, and I know that she will not adequately thank herself. So I want to make sure, at least now, that Janet Cleveland get adequately thanked for organizing this conference, for doing tremendous work, alongside Marie-Ève, of course. So Marie-Ève and Janet have made this happen. I had the idea, and then I got pregnant with twins and made them run with it. So thank you to them, and to the two institutions, Sherpa and to the Division of Transcultural Psychiatry, who have not only lent tremendous labor, but have created the discursive space and the culture that allows these kinds of things to happen.
Do have a good time for questions, for comments, I think the three panelists are really raising very important contrast and questions about how do we put the focus, emphasize or minimize these national differences. Is it that some people are better than others? How do we think that? This is a key question, because we may think that some countries are better than others, and they may be, but I'm not sure we're so safe. So there is a question about local versus global phenomena. How do we think the balance? There are also questions that you raised, which are very important, which is what are the double edge of our practices and of our work? When do we help and when do we harm? And I think this is a very serious question that you've raised. So I open to you, all of you, for comments, questions, and let's have a discussion.
Thank you so much for your presentations. It was very interesting to hear the very disheartening news of child detention in these different contexts. I was interested to know if each of you had any reflections on the role of international political discussions on national discussions about child detention. There's been some significant developments internationally around this issue, and I'm always interested to know how much that trickles down to any kind of influence at the national political sphere. So I'm thinking in particular of the fact that for instance, there was a joint general comment released at the end of last year that clarifies from the Committee on Migrant Workers and the Committee on the Rights of the Child that child detention is always a child rights violation. It's never in the child's best interests. So does that ever fall into the discussions and also the current negotiations on the global compacts on migration and refugees? Do you have any sense of interactions of national and international level politics on these issues? Because I know each of the three nations you are talking about have been pushing to retain the right to detain children in those compacts. Thank you.
I think that for better or for worse, this does make a difference, and when it works well, that is, when it works for the promotion of human rights, international scrutiny, and comments by international actors makes a real difference. I think that even with the most intractable, obstreperous actors. I'm thinking here, of course, of Donald Trump, but not only. We have a famous former prime minister of Australia who said that they were sick of being lectured to by the United Nations. I still think that those international statements make a big difference. The High Commissioner for Human Rights said last week in Geneva that what was going on in the U.S. amounted to child abuse, and that is clearly the case. The U.S. is running for cover. It's withdrawn from the Human Rights Council, as many of you may have heard, at 5 o'clock this evening, in large part because of its position on Israel, but more generally because that is a space where it is subject to international scrutiny, and it doesn't want even a relatively toothless forum where it can be held to account. So I think these things do make a difference. I know in many of the other contexts in which I work, responding more specifically to the Joint General Comment, and which is a statement, an authoritative statement by 2 UN bodies charged with interpreting the binding content of treaties, as well as a political commitment made in the context of the Global Compact, that those things do have are taken quite seriously outside of the United States in particular. One context that I'll just mention briefly is that the European Union, which would prefer a much less stringent standard, which would prefer a lot more flexibility to lock kids up, is quite nervous about the language of both of these things.
I think the first thing is to say that things fluctuate all the time. And I guess that, in 2006, we all felt very cheered up in Australia when, children were out of detention. It was, again, the last resort. All of that happened. So politically, things go up and down. And at the moment, they're definitely going down in Australia. So in terms of international, but it's sort of, I guess one of the things I think is that we have to keep on saying and looking to international bodies to say what should be happening for a humane world, at the same time as recognising that it's, it feels very dangerous at the moment in the whole world, like there's this sort of infection of harshness and inhumanity sort of spreading everywhere. But, I mean, there are sort of rumours as well about someone taking a case against Australia to one of the international courts. There's moves to try and use the international bodies. So that's one part of it. When I sort of provocatively said, have we been too effective in presenting the evidence? I mean, in one way, I think, and I know you're very much thinking about advocacy. I think it's how do we get smart so we turn it around again so that it can't be used? Because it feels like if we keep saying the same things, this is wrong, it doesn't go anywhere. But the other thing is that at a local level, sort of in the Australia-Pacific region, for example, New Zealand, who Australia loves to denigrate and make jokes about, but nonetheless is quite close to. New Zealand offered to take quite a lot of the people who are in this limbo on Manus and Nauru and has been turned down. A few people have been sort of traded with the US, but not very many. So Australia still needs friends. I mean, all our countries need friends, and you can see all the shifting alliances and allegiances, but the politics is still the politics. So I guess it's like it has to keep happening on a number of different levels. I'm not an expert on this.
Yeah, I would say I would want you to speak more to my legal colleagues about this, and certainly the people who are advocating in this area, the legal advocates are paying attention to these things. I'll just give one small example where I think, the discourse of human rights is kind of eroded and vanishing. This was a very small side project that took me a very long time, but I did an analysis of a parliamentary debate on Bill C-31 that was going to see asylum seekers mandatorily detained when they arrived in groups. And I'd have to go back over the 500 pages, but the arguments that were harnessed in those debates in our parliament, which would be an awfully good place to talk about international law and treaties, those arguments appeared very, very rarely. Very rarely. That was not what parliamentarians were using to be persuasive. They were telling stories. They were trying to implore people to be compassionate or implore people of the dangers of migrants. But human rights were low on the agenda. So I think my legal colleagues could speak more to that, and also NGO colleagues who are of course paying attention to these things. But in the general discourse, less so, is my feeling as a non-expert.
I have a question and also a consideration. Well, the US pulled out of from the Global Compact on migration altogether, so they are not part of the Global Compact on migration anymore. The issue about the Global Compacts, both of them, is that they don't mention anywhere the right to healthcare and the right to mental health of migrants and refugees. So they have been totally wiped off, from the discourse at this point in time. And I think it's very relevant because we are talking about detention in the context of mental health care. And this is probably a discussion we should have. I have just a question for you that is, and maybe that's a consideration for everyone. What makes the difference in the decision whether the child go with the family in detention or with the child, whenever there is another parent, I understand, but with the child protection service out of detention? So what is this decision based on?
Well, this is a good question because it's not always clear how that decision is made. I think that's my main answer. There are cases certainly where the parents are able to choose, where an officer is given, it gives the parent the choice: do you want to be detained with your child or not? This is anecdotal, but from people working in the field, I've also heard cases where parents have just been told you are being detained and your child is not being detained. But what's troubling is we don't know exactly how those decisions.
So there is not a standard operating procedure. It's just
no. This is in process. I mean, Hannah, with you and with your UNHCR colleagues, NCUSA was developing this assessment tool to take in consideration the best interests of the child, but we're not sure where that is now.
Okay, thank you very much.
Julia, we have a gentleman there. No, we have two.
We had this funny point in Australian history where the immigration minister, because we were saying children out of detention, so the immigration minister at that time, Mr. Ruddock, said, all the children could go out of detention. And then, but the experts say the children shouldn't be separated. Are the experts confused? It's very dirty politics everywhere.
I was just going to, thanks to all the speakers for their presentations, very incredibly illuminating about such a dire topic. Given the harms that we've been hearing about and the damage and the knowledge of governments about what they're doing, certainly in Australia, no question, and the awareness of the direct and the indirect effects of that. So governments know, and they know the effects of that, and the impunity. And also the discussion about torture, in responsible academic circles about in this context. Do the speakers have any comments to make about, cases related to negligence or to compensation? So what's been happening in this area in relation to children in particular?
Well, I was involved in providing considerable evidence for example, in Australia, there have been compensation claims, which was going to be a class action. And very disappointingly, once a great deal of evidence had been gathered, it somehow got ruled that it couldn't be a class action and that it got settled just with the family. But there are, in Australia, there's an increasing number of individual cases and some attempts at class action in relation to detained children and families and also adults. But there's also been questions about class actions in relation to the harms or long-term suffering of the detention workers because of their trauma.
Maybe I can add that because it's a very important argument. We are breaching our own laws of child protection with an exceptionality. So we've used that in argument to involve Youth Protection Authority in changing the access of undocumented children to school under the claim that this was hindering their development, and that youth protection would oblige and even take away any kids that their parents would not put in school. So what about if the state was not permitting the kid in the same territory to be in school? So I think that it raises, what you're raising, a very important argument that I think we should push forward to involve more our youth protection agency, which are often very cold hand in those matters.
So to answer some of your questions, first of all, the spike in detention numbers this year is in relation to a significant influx of inadmissible individuals from Mexico that are turned around within 24 hours. So they're detained. The detention is to get the individual back out on the next flight. So that has caused an overall spike in detention numbers, but for very, very short durations of time. With respect to minors, our Q4 stats and our annual stats for 2017-18 are in the approval process. But in Q4, so January to March of 2018, there were 12 individuals detained, which is down from 38 in Q3 of 2017. It's important to note that the Minister's Directive and the National Directive on Detention Minors came out at the beginning of February 2017. So it was only in Q4 that we started to see a noticeable difference. So it will be interesting to see what we see in this fiscal year once we get a full year of data with the directive implemented. With respect to the regional differences, it is something we're aware of and we continue to monitor and look at to try to better understand what the reasons are and fully address it. Particularly since the directive was implemented, there's further increased oversight regarding the detention of minors and looking at the reasons when a minor is housed with the parents. The detention number itself is down. The vast majority of minors that are now in one of the holding centers are accompanying their parents at the parents' choice because no viable alternative was able to be identified. With respect to best interest of the child, the guidance that exists is currently what is in the national directive and in the regulations. Based on that workshop with the UNHCR I participated in last year, we are working on developing a tool for officers on the front line, recognizing that those officers don't have a lot of time to make a decision, nor the expertise. So we're trying to come up with a consistent manner of documenting the decision, the initial decision, if the parent's detained and the child's housed with them. But then a further, more robust tool if they actually are held in the detention center for any period of time, say 48 hours, to pick a reasonable number so that there's further assessment regarding the impact on how the child is doing. In all cases, the expectation is that all alternatives to detention be fully explored. And the starting point is that we try to release the family unit. Anecdotally, I've been told in some regions if they have to, they will keep the head of the family and release the other parent with the children, so separation may occur, but the children aren't being housed. With respect to whether or not child protection services are engaged, as a general rule, they're not. When we use child protection services, it's in the case of an unaccompanied minor if no one can be identified. If the child has parents with them, they're either outright released with the parents, or if the parent is detained, the children may be housed with the parents, but that's on the parent's consent. We generally wouldn't use child protection services where there's a family unit. I think I addressed all of the questions, but I'm happy to respond to anything else that I can.
Just going back to what you brought up about child protection services. In Australia, there are different federal and state jurisdictions, and states generally manage child protection. This is not child care, it can be child removal, but it's when children are deemed to be at risk. And in the past, there have been attempts to use child protection legislation, and in fact, many, many children have been reported to child protection services when they were being neglected and not provided with care and exposed to violence and all the rest of it. this is separate from when particular notifications have been made about abuse within detention, either by parents or by other adults. But generally in Australia, the issue is that people who are seeking asylum are not deemed to be in Australia. They're deemed to be in some other place that's not anywhere, and therefore child protection legislation doesn't apply or is trumped by immigration law. So, but it's a very important issue, I think.
Just to add to that, and going back to the more general question about accountability for these kinds of abuses in litigation, I think it's quite difficult in many jurisdictions to bring effective legal challenges, and that's true in general with regard to facilities that are clearly located within the physical territory of the country. But what's astonishing more recently is the lengths to which some countries go, Australia among them, to really insulate themselves from legal accountability. So the United States once put a refugee camp on Guantanamo for the purposes in part of insulating it from court challenges. Australia drew on that model when it established Papua New Guinea and Nauru. It miscalculated with Papua New Guinea because there actually was a court challenge, and the court said this is illegal and ordered compensation. Nonetheless, that camp is still there, but there are quite a lot of barriers that are set up precisely to avoid these kinds of challenges. And the legal fiction that you just heard about, that somebody who's clearly physically, for all purposes, in reality in Australia, isn't legally in Australia, is only one of the many hurdles that people have to face.
Yes.
Yeah, a short question in European rights case law, the Court of Human Rights, they've developed this extraterritorial control philosophy, or I don't know how to call it, which in Europe can work because we have this supranational court, but obviously in the United States and in Australia and Canada, there is nobody above. So is it something that has been tried by, legal advocacy to invoke extraterritorial control, as they call it? We say, because after all, even if they are on Nauru or on Guantanamo, it is still the state that put them there that controls it, so they're still exerting sovereignty, basically. So is it something that has been tried? Just curious.
This legal idea of effective power as implying state responsibility is well established as a matter of law, and and you can make convincing cases. Let's take the example of Nauru. Australia flies them there. It pays for everything. It essentially treats Nauru as a client state and props it up with a lot of money. There are, and I'm just scratching the surface with the level of control that it is exercising. So in every moral sense, it is responsible. That said, the idea that it would be, I don't think there's been any effective court challenge within Australia. You can add to that. I do want to, before I pass the microphone, mention the case of Guantanamo in the counterterrorism sense. So U.S. courts have not accepted the idea that Guantanamo is a place beyond the reach of the federal courts when it comes to, for example, torture or access to counsel. There's been effectively an adoption of that analysis to say, look, we don't care where you put people. The reach of the U.S. Constitution and the U.S. courts follows, at least to some degree, when we're talking about certain extreme harms.
So Australia doesn't have a Bill of Rights, and although a signatory to the various UN conventions, the relevant ones, they're not enacted in our law. That's one thing, particularly the Convention on the Rights of the Child. As I say, there are rumours that a case may be taken in the International Court, but unfortunately, when our Australian High Court the appeals have gone to the High Court in terms of the legality of detention, including of minors or mandatory indefinite detention and so on, it has turned out to be legal under current Australian law and constitution. So And then there was another case about whether babies born in Australia were Australian, and then it was again the court decided no, actually they were illegal maritime arrivals, even though they had been conceived in detention. So there's a lot of ongoing attempts to use legal means and to work with lawyers and advocates, medical experts together. But it's a very, you have to just keep going with it.
I'd like to perhaps just a little bit of provocation, if you will, to sort of ask why you think that we're still fighting child detention. I mean, why? How come we haven't won this battle? In a sense, because not only is it the sort of the very obvious moral rightness of denouncing, of saying that no child should ever be imprisoned, certainly without any criminal action, all the more reason. Children should not be separated forcibly from their parents. So there's that level, which, at a certain level one expects everybody kind of agrees with. Like those are, But also, I mean, if you talk to, when we were doing the research in the detention center, for example, management in detention center clearly really are very uncomfortable dealing with children. They would say to us, like, sort of, it's not what we're trained to do. It's not what we're meant, they wouldn't say exactly in those words, but it's not what we're meant to be doing. It's not our role. I mean, again, and I think if you talk to officials, often there's a sense also, border control officials, there's a sense that that's not their business, It's so. Anyway, I just perhaps like to turn it around a little bit in that sense. Sort of, why is it that we're not succeeding more than we are?
In Rachel's analysis of the parliamentary debate, there was an interesting thing about inversion of identity. So sometimes kids were identified first as potential criminals or potential dangers before being children. So you have that kind of the shift, and I think that these forms of dehumanizing phenomenon may be in part responsible for what you're naming. But
I feel like it's hard to be Australian, but anyway, there are two words came to my mind, and one was laziness and the other was politics. I think there's been a lot of short-term political gain in Australia from demonising asylum seekers, inflating the threat, conflating terrorism and people who seek asylum, the people who are fleeing, the wars that we're supposedly supporting and so on. I did say, though, that I think detention of children has been much less politically palatable. And then the lazy part of it maybe comes in terms of not actually changing the policy and law that has enabled that to then happen again when there's been another big influx. So partly it's been a lack of follow-through in terms of, yes, all the children are out of detention, it's a policy of last resort, etc., because the Human Rights Commission, not everyone agrees it shouldn't happen. And then there's a big upswing again, the war in Syria or Afghanistan or whatever it is, and people come. And I think that you were talking earlier about how sometimes it's easier to change things when it's not in the spotlight, because politically the stakes are so polarised in Australia about the whole issue of being tough on we'll decide who comes and so on. So maybe more effective advocacy can happen. I don't know if you want to talk any more about that, but when it's not in the spotlight, and that seems a bit, it's as if it doesn't get followed through, the legislative and policy and legal changes that would need to make it actually not possible for it to keep happening again.
While the microphone is being passed, I think that one of the things that Rachel said is effectively when we're discussing the utility of legal standards versus other things, that one of the most important things is telling stories, right? Is telling the human impact. And that's something that I tell law students all the time now when I'm teaching human rights advocacy. I think there is quite a lot to this, the conscious changing of the narrative. And so what we're certainly seeing in the United States is the use by the president and the others in the administration of terms like gang member, potential gang member, criminal, really demonizing language, including a lot of manipulation of the images that were released. People noticed in the last couple of days that there were no images of girls or young kids, even though I saw plenty of those when I was in those facilities. And I think that's in part because, boys are considered dangerous, and older boys even more so. And so it's a way of reframing this debate, and I think there has to be a way of shifting that. But I think the microphone is now up to the speaker, the questioner.
Thank you. No, I just wanted to go back to the question regarding regional control, judicial control or supervision on human rights abuses in this area. And just to touch on that issue, we know that we can't take a case against the US or Canada before the Inter-American Court of Human Rights because they are not party to the American Convention on Human Rights. But there have been cases in other areas, such as indigenous rights, that through the OAS Charter, the Charter of the Organization of American States, and the American Declaration on the Rights and Duties of Man, American in the sense of the whole continent, right, to which the US and Canada are a party to, that some cases have been brought to the Inter-American Commission on Human Rights, even though not to the court. So the first stage, we still have in the Inter-American system a dual system, as there used to be in Europe before. And the other way that we have gone about trying to set regional standards in human rights is requesting for advisory opinions. So not through the contentious jurisdiction of the Inter-American Court, but through its advisory jurisdiction. Mexico requested the Inter-American Court on Human Rights an advisory opinion on the rights of undocumented migrants. And the court issued this advisory opinion that while it's not binding and doesn't refer to an individual case, it's an authoritative interpretation of the human rights standards of the region, saying that rights of undocumented migrants, in that case it was specifically labor rights, are jus cogens, so that's general imperative norm of international law. So there are certain legal spaces, I think, to be worked on and carved out that can help us in the region, and even if it's not direct judicial individual cases.
It's just a quick reflection on what you were saying, Sarah, about the fact that about the politicising of asylum seekers and their demonising and being demonised in children. And if you consider that we're wanting to outlaw child detention, but we're also wanting to outlaw the issue of family separation, then surely that's a significant loss to governments to lose both those things. You're getting a whole large numbers of people, families, that are going to have to be accommodated in toto out of detention. And I think, at least in Australia, knowing that situation very well, I don't think our government will tolerate that easily.
It's just funny, though, that they're willing to spend billions and billions and billions when it's so much more expensive to detain people than to house them in the community. So it's as if also, if politically there was a way of changing the discourse as well, so that it was better to spend the money on something else. So it's hard, it just doesn't stick at the moment.
That's precisely the point that I was going to make. I was on Nauru a year and a half ago, and it's shocking to see the amount of cash that's flying in to that country that's all due to Australian government spending on detention. And so when I looked at the official figures, the published figures that Australia finally admitted, or the government finally admitted to in Parliament, and tried to figure out what that would be, what that would equate to, I worked out that it costs more to put somebody on Nauru than to send them to Harvard College for 4 years, and that they could buy them Mercedes-Benz or Bentley every year for that price, or put them up at the Ritz, maybe 2 or 3 different rooms, a suite for them. I mean, the amount of money that they're spending is just shocking. And then just to turn to the U.S., there's quite a lot of money that's made in private prisons and private contracting. There's some serious interest at stake in locking people up.
I think this is an argument we should further develop in advocacy. Around undocumented, it's easy to show if you do not school a kid, the loss for the society will rapidly pay the cost of schooling all undocumented kids in the province or in the country very rapidly. So what I think we haven't done for detained kids, cost analysis of the cost in terms of long-term impact, impairment of psychological and developmental issue in terms of cognitive loss and emotional problems. This is certainly possible to do, to say to people, this is very costly, beyond detention costs.
No, countries are putting up their hand to take all of these people who have been, progressively further harmed over the last, years by being in this limbo in Australia. I mean, they need so much more than they did when they first came. And it's very hard to see politically, having taken that position, how they're going to step down from that. It's almost like there needs to be some other distraction, and then quietly people can be found somewhere to live that's not torturing them.
I think I will propose, because we're all tired, you've been very, very patient going through the whole day, maybe just to have a word from all of our speakers to wrap up this very nice session, and then go and have a nice walk or sleep or dinner or whatever.
So I do have one thought. I mean, along the lines that I think stories and human accounts are important to change policy far more than laws, court cases, and so on. I think that there is a lot of value in presenting evidence of the mental health consequences of detention, things like that. I think that there is still quite a bit of respect by lawmakers, by politicians, by the general public, when it's put in plain terms what the human cost is on people. I think that can be very, very effective.
First of all, it's really great to talk about this together, although I know we don't all want to go down a spiral where we all end up feeling depressed. To me, it feels very heartening to be sitting with you from all around the world and trying to think about this together, because I think there's a great deal of strength in that, and sometimes we do feel a long way away. And Australia got a seat on the Human Rights, committee or whatever it was just last year. I'm not saying the right terms, but somehow there's this real split in what the awfulness of what's happening and how we strut around in the world. So it's very heartening to be able to think and talk about this together, and to hear about different perspectives, and to continue to share a kind of faith in humanity overall. I think that's really important.
And I'll say from the Canadian perspective, well, I don't think we can be smug, or we can become indifferent, or say there's no change to be made. We can acknowledge that there's been some traction, and that we have the ear of CBSA, and that you are working to make changes, and that the government is responsive to the call to end child detention and end child separation in a way it hasn't been before. And so, yes, there's more to be done. Yes, there's much to be concerned about. And yes, there's some hope. And there's some real dialogue that's begun happening around this issue.
Thank you, and good evening.